Yesterday I came to know about an incident. No case has been filed, but in all probability it may materialize into that kind of situation. It's a very simple case, but at the same time, the complexity, in my opinion, it comes out very clearly. A dental doctor, MDS, and I think she is associate professor or something like that. Husband is a professor of dental again, and working in the same college, etc. 33 years old, first delivery LSCS, girl child, second delivery. I mean, it so happened, I mean, it's rather a very, very unfortunate. For some reason or the other, mother never wanted to carry through pregnancy, the second pregnancy. We don't know why, but she always felt that she is apprehensive about, I don't want, etc. She came and asked for a termination when she was around second or before second month. But doctors, they advised, no, you have only one child, why don't you go for a second child? I mean, see, you know, normally, culturally, that kind of communication is not uncommon in our context. Maybe in US or in other country, that kind of communication may not take place. But culturally, we try to identify the bonding, feeling, etc. Then it so happened, people convinced her, and even husband, very nice of him, he said, it is up to you, whatever, because I know how much suffering, how much pain, etc. I leave it to you. Then she said, no, let's carry on with the pregnancy, etc. And the same doctor, and these people, they were living in the locality for the last 27 years. These doctor's son also is doctor, doctor's daughter is also a doctor, they are also, I mean, lot of. Then ultimately, they approached towards the delivery time. And the doctor said, if it is Friday, I am not available because Friday I have a meeting in Bangalore. Therefore, we will return on Monday, let us do it on Monday. And I think you have that kind of. Then she said, no, do it on Thursday itself. And accordingly, LSCS, etc., everything planned. Anesthetist was there, pediatrician was there. I mean, doctor is a general surgeon, but wife is a gynecologist, same hospital, same nursing home, everything. And she wanted very particularly tubectomy. She said, I want to concentrate on my career, etc., even husband and wife, everybody. And accordingly, LSCS, classical LSCS was conducted, and accordingly, the baby was retrieved. Now, the point is, the moment delivered, etc., and everything, etc., for about 45 minutes, everything went on very well. And it so happened, husband was present while retrieving takes place, because he himself a doctor, he wanted to be there. After 7 minutes of the entire process, she developed some involuntary movements of the hands. Okay? That one doctor told me it is a convulsion. Whether it is a convulsion or involuntary movement, I am sure as doctors, I am not a doctor, you know, every involuntary movement need not be a convulsion. Okay? But convulsion definitely takes within its fold some kind of movement, etc., which can be called involuntary or some other word can be used. That's what, as a layperson, I understand. Then, within 26 minutes, she passed away. Okay? Now, the pregnant mother, brother is a doctor who is a gynecologist from Pondicherry Jipmer. He came running next evening or something like that, and everybody, and the doctor, everybody. The social situation you try to understand, the doctor knows this lady for the last 27 years. Even for her birth, he went there and gave a gift. That's what he told me. Even for their marriage, this, that, his son, they're all classmates, they used to come, I mean, that kind of interest. And now, for the doctor, at that moment of time, should he suggest a postmortem or not? That was the communication. Then somehow somebody said, it is better you go in for postmortem. That's what doctor suggested. But somehow our husband doctor felt, no, I don't think we should go in for. After all, she is not there. For what purpose? And what could be the reason? I just want to know. They said, in all probability, some kind of cardiac arrest, etc. That is the thing. Then other members also felt, no, let it not be. And accordingly, the body was cremated. Okay? Same day evening. This took place around 11:10 or something like that, death. And within half an hour informed, etc. And evening before 6 o'clock, you know, before sunset, bodies to be, they have done it, everything was over. For 2 days, absolute calm. No talks, no phone calls, nothing. Either from this house or from that house. Thereafter, many people involved, naturally, you know, sympathy, unsolicited talk, so many things happen in our day-to-day life. And happened, etc., etc. Then the friction started like anything. And ultimately, the brother of the pregnant mother felt that you have miserably failed to manage the case. You have failed. You have failed in handling the case. What is the possible reason? And I want to see the medical records, etc., all that. You know, if the friction triggers, there is no end to that. Then because body is burnt, there is no question of everything, what kind of cause, etc., The physician made an observation, even gynecologist made an observation. They said amniotic, embolism, liquid embolism, okay, fluid embolism. That is the cause. Then they said, I asked, my first question is, you know that it is a known complication, right? And you say that around 80% morbidity or mortality is there. That's what you claim. Tell me, what did you do to prevent? In fact, doctor came to me seeking legal advice, but I became the devil's advocate. I said, this is what I want to know. Suppose if the husband or brother, somebody asks, this is what anybody will ask. What did you do? Whether it can be prevented, this, that, etc. The discussion went on for about 3.5 hours. I said, even though you came to me for my legal advice, I want to tell you these are the questions that will come up for scrutiny. Therefore, we need to look into what happened. And ultimately, they did some research. Somebody said, this is the write-up we got, and the write-up very clearly says, no, it is not preventable. This is something may happen kind of thing. What could be the positive, causative factor? That is my question. They said when the placenta gets separated, etc., there is every possibility an air bubble, etc., and accordingly embolism may result, and it could be fatal, life-threatening, this, that, etc. Again, for that my question is, can it not be preventable? If so, what needs to be done? That is what my devil's advocate question. They came to the, no, it is not. In such a case, how many cases happens? Suppose, had it been in some other hospital, you think it would have been prevented? They said no. Had it been some other thing, in such a case, does that mean that it is left to the destiny of the pregnant mother, whether she is going to experience embolism or not? If so, she is going to die. If not, she will be alive. Is it something like that? They felt my questioning is very, very problematic. I said, these are the questions which will come in the court of law. Now, in the backdrop of this particular, I said you the complexity. You remember, I mentioned it's a very simple case. These cases happen day in and day out. You know, the kind of private hospital nursing home deliveries, day in and day out these things happen. But sometimes the issue becomes so crucial, so complex. See, pulmonary embolism leading to death is not uncommon. There are several times it happened. In one of the case, we lost very badly. In fact, I was representing a doctor. He has done hysteroscopy. Okay, hysteroscopy, it so happened, led to pulmonary embolism. She developed breathlessness. It came down everything. She was shifted to some other. On the way in the ambulance, she died. They filed a case for medical negligence. I personally argued the matter, saying that there is no negligence on the part of the doctor. The judge rejected the argument. But he found a shelter by saying that, no, in your hospital there was no ventilator. Still you have conducted this procedure. Because you don't have a ventilator, you are deficient in service, and asked us to pay 3 lakhs. That's what we have challenged in the National Commission. We said, in how many hospitals, how many ventilators are there, how many people can afford having a ventilator, and ultimately, after all, what is hysteroscopy? Hysteroscopy, please correct me, you are all doctors. It could even be conducted on OPD basis as well. That's what many times it happens. Nowadays, the corporate healthcare structure, etc., many people get admitted. That's a different matter. But otherwise, an institution, a small nursing home, a 10-bedded or 30-bedded in rural areas or semi, these things. I tell you, whatever the argument in terms of the law and interpretation, I was absolutely bulldozed. In fact, judge told me, no, I don't accept you. This is the thing. You are insensitive. You are not concerned about the death. I said, no, the point is not whether I am sensitive to the death or not. I am sensitive to death. I am very sympathetic to the patient. But here, should it be subjected to the negligent contact? Could it have happened only because of negligent contact? Then he gave that kind of judgment, etc. What I want to tell you is, in Indian circumstances, these cases are plenty. In fact, there are cases where the husband, even though he is a doctor, he told me, Jogaro, I know what is allopathy medicine. I am an orthopedician. I know that. But I can tell you, there are so many areas which are absolutely gray in area. And I don't think anybody can do anything. It is the destiny of the person who is receiving the service. That's it. He lost his wife. He said, I am not going to file a case, etc. Because I know some problem here and there. In my own orthopedic specialty, these problems we face day in and day out. I mean, that's how he ended it. Some people react very sharply. Some people may create a law and order problem, this, that, etc., and they say medical negligence. And I am sure this particular case, in all probability, will go to the court of law. The backdrop of the socio-cultural and economic phase, if you look into, one important aspect you need to appreciate. In India, the judicial understanding about medical negligence and the processes that are employed to decide whether there is a negligence on the part of the doctor or not, permit me to say, it is not matured in nature. Even today, I can tell you there are very few cases where objectively justice dispensation takes place. I am not saying that I appear only for doctor and I ask for, no, there are cases where I appeared for patient. To tell you very frankly, I find it, I wouldn't say extremely, relatively easy to defend a doctor. But when it comes to a patient, to defend his interest, I find it extremely difficult. Despite the fact that the judge is pro-patient in nature. Because the burden of proof on the part of the patient is so tough. Medical literature you have to look into, the processes, no help you can expect from a medical doctor. Normally, the patient is absolutely isolated when it comes to such kind of thing. In any other country, I am sure neutral experts are there, where you can go and seek their expert evidence and they can come, etc. In Bangalore or in India, it's very difficult to get an expert. That is the reason why judges, they say, no, even though expert is not forthcoming, we know that nobody will come. In medical literature can be shown. And that's how the leaning towards patient is always visible in judicial dispensation. But having said that, as a matter stand, the maturity you don't find. Somewhere you want to dispose of and you say on that factor, this factor, and dispose of. Or you pay this amount or you pay that amount. I mean, that's the kind of situation what we are happening. In the light of all these factors, we need to understand at a basic level, what is that medical negligence we are talking? What are the challenges? See, everybody doesn't appreciate, nobody appreciates the challenge that is involved in a medical negligence case. I am not saying that the knowledge on the part of the lawyer or judge about scientific aspect, that is the minimum requirement whenever you decide a case. It is something like if you are not a gynec, you attend a particular hysterectomy operation, how do you face the challenge? Same thing for a judge. He doesn't know anything about medicine, he doesn't know anything about specialty, but he was asked to decide about whether the doctor is negligent or not in a given case. How does, same thing here. But that is always there at a fundamental level. But much more than that, the processes that are involved, the kind of evidence that is to be introduced, what needs to be given in a given case where the doctor thinks complication, but there is nothing to show that he was not negligent. Take this particular case. This fluid embolism is a complication, every doctor votes, no problem. But in what way you can say that the doctor is not negligent? Similarly, the burden on the part of the patient, because there is a complication, death took place, that is not negligence, that everybody knows. But what evidence he has to show that even though there is a complication, still there is room for negligence on the part of the doctor. I mean, that's the kind of very nicety and the very peculiar intellectual challenge you get. But unfortunately, the judicial system is not matured enough. I mean, no doubt judges do claim that no, over a period of time we have maturing and evolving principles, etc. But still, when compared to the international response, we find extremely feeble response. I mean, that's where we have to take as they come. That's the situation. Okay. Now, in the light of all these things, as I always start with my first slide, tremendous regulation of medical practice, please remember. It is such an influence of law, ethics and regulation. Unless and until we really understand and appreciate. Many people say, no, there is no law statutorily. That is a enacted, specified, codified law. As I told you last time also, even though there is no enacted, specific or codified law, medical negligence is governed by common law, which means it is unwritten law. We look into judicial precedent, that is what we call law of torts, TORTS, which deals with civil wrongs. Even though there is no law which is codified, still there is a law which is unwritten, so you are bound by that. That is the reason why you need to specifically understand and appreciate what are those elements, what are those pros and cons when we talk about medical negligence. For instance, This is something we need to appreciate. Globally, the social awareness about patient rights has come about, I would say, 40 to 50 years ago. But in Indian context, please remember, it is only after Consumer Protection Act vis-a-vis medical profession has come into being, then people started realizing that there are certain rights which needed to be respected. Medical negligence is always viewed in the isolated perspective of doctor versus patient, but not in the context of doctor and patient. Please remember, adversarial relationship is different, a complementary relationship is different. I hope I am communicating. Doctor versus patient is different from doctor and the patient. My dear friends, you can only become a doctor only when there is a patient. Take it from me. Otherwise, you would not have got your degree. Either the patient in live condition or in a deceased condition, doesn't matter. What kind of anatomy you would read without the dead body of the person? What kind of diagnosis we are talking when the person is, no sick person is available? Patient is a fundamental, foundational. Not only for acquiring your degree, even for your medical practice, you require a patient. Then only you will be able to do practice, you will be able to render service. People now started realizing, no, it is not merely in what way you can protect your interest, but also how to respect patient rights. You know, we talked about Consumer Protection Act 1986, where consumer, patient is also a consumer. A patient is a consumer of healthcare services. Patient is a consumer of healthcare services. That is the reason why a patient is brought under the ambit of Consumer Protection Act 1986. That is the global trend. This is something very, very crucial for us. When we talk about this, I have already mentioned, when we talk about the legal remedies, in India, the patient has multiple legal remedies. They are not exclusive in nature. There is a possibility in one case there can be 3 court cases. Constitutional law, that is, if the government hospital or doctor is involved, a writ can be filed. For example, NIMHANS. If there is negligence on the part of a doctor, a writ can be filed in the High Court or Supreme Court. The case where the Supreme Court has decided that right to health includes right to life is a very interesting fact situation. One patient, Sialda, near Howrah station, was about to board a train. He fell on the platform. He received head injury. He was taken to a PHC. They said, beds are empty, there is no problem, but no doctor is there, no nurse is there. He was taken to another PHC. They said there is a doctor and a nurse, but beds are not empty. Because a huge tragedy took place, 136 patients are there. The bed capacity was only 15 in number. Then he was taken to some other hospital. They said nothing is available. If you want him to die, this is the best place. You need not take him to some other hospital. Then he was taken to a private hospital where survived, revived, happily, no problem. Survived. Please remember, survived. Then he filed a writ petition in the Supreme Court. He said, what kind of health we are talking? I was shifted from hospital to hospital to hospital. Luckily, I got survived, which means I survived by accident. I survived by accident, though my death could have been due to accident. You got the point? Supreme Court, he said, Supreme Court, you must do something about it. What is this country? Is that so? That there is no PhD, there is no doctor? Then they sent notices to government. It's a huge case. And I can tell you, some kind of momentum has been initiated by that case. And the Supreme Court understood the reality of the problem. Please remember, I told you, my dear friends, if you have money, if you can afford, there is no problem for you. But if for a moment, think about a person who cannot afford. Because healthcare has become such a complex issue from economic perspective. As a result, I am coming back and say, Supreme Court also realized. Supreme Court said, oh, this is the kind of thing. Then people mentioned why medical litigation is increasing in this country. Because neither, a private operator, he shrugs off. He says, I have taken loan from the bank and I have to repay the loan, therefore you have to pay the fee, then only I can survive, otherwise I will close the shop. That's what private person says. The government says, God, no, we don't have money. If government doesn't have money and a private person wants money from you, where will you go? That is the issue. Supreme Court realized, and they said, no, the best way to do is to consider right to health as a fundamental right. That is how right to health, even though it is not written in the Constitution as a fundamental right, it was interpreted to be as a fundamental right. Okay? That's where the context of where multiple legal remedies the Supreme Court has examined. Second one is civil tort law, that is civil regular civil court. Can anybody tell me the difference between the tort law and consumer law? That is, in the regular civil court you file a case, or a consumer court you file a case. What is the difference? Yeah, in the case of regular civil court, you have to pay court fee. Normally, suppose I ask for 10,000 rupees compensation, I have to pay 7.5%, which means 750 rupees I have to pay. But in the case of consumer law, it is not that much, but it is very minimal amount, 500 rupees, 100 per lakh, again a cap is there, that kind of thing. Therefore, please remember, a regular civil court, that is tort law, either tort law or contract law, the person who is claiming compensation has to pay as a court fee. But in the case of a consumer law, there is no such thing. In case of criminal law, it is a criminal prosecution. Please remember, as I told you, the victim need not engage a lawyer. It is the doctor or hospital, they have to engage a lawyer. Because for the victim, it is the public prosecutor who is representing state will argue the case. I said there are parallel. For instance, a case can be filed in 304A in before the criminal court, and a consumer court can also be filed. In addition to this, I also mentioned to you ethically the state medical councils, where the complaint can also be filed before the medical council. In fact, one reason which I personally feel justifiably why the medical fraternity feels suffocated is because of this reason. They say parallel, too many remedies. I mean, that's something in India we need to really look into it. When we talk about legal regulation, my dear friends, there are three areas as of now which are very crucial: medical negligence, consent and informed consent, and confidentiality. These are the three grounds. Statutory complaints means any statute which mandates a particular procedure, MTP, PNDT, Mental Health Act, Biomedical Waste Disposal, or any statute which gives such kind of complaint procedures, then you have to follow that. Or for example, blood bank. I mean, under what circumstances, if you want to initiate, start a blood bank, what are the formalities you have to follow? Under what circumstances transfusion can take place? Various issues. In all these things in India as of now, the major role of litigation is played by medical negligence. As matter stand, not only in India, in majority of the countries, the experience is medical negligence has become a political debate. Okay? Then followed by consent and informed consent, and confidentiality in a limited manner, particularly the disease like HIV positive, where social ostracization or possible, why possible, potential discrimination of the lives of the people takes place, naturally the confidentiality. Now let me start with the case studies. To begin with, let me identify what are the specialties I am going to look into. Number one, physicians, obstetricians, orthopedicians, surgeons, anesthesiologists, institutions, that is the nursing home or hospital, and medico-legal issues. Medico-legal issues means, as I told you, unnatural death, or where any illegal or offensive conduct is involved, which results in harm to the body. I hope I am communicating. Road traffic accident, it is medico-legal case. Stab injury, medico-legal case. Poison case, medico-legal case. Therefore, you need to look into that kind of offensive conduct, where the conduct which is per se illegal in nature results in harm. Either harm means either death or disability or hospitalization, whatever you have. Okay? Let me start with the first one. As I told you, all these cases, they come from my own experience. All the case files we have examined, and each one I will explain. To begin with, an overview. In the case of physicians, the following issues have cropped up in different cases. As I told you, majority of the litigation we are referring in the context of medical negligence. Consent and informed consent may marginally form part of the, but otherwise medical negligence we are. In the case of physicians, the competence of doctor is something which normally raised as a legal issue. Patient referral. What is CSJ's? Steven Johnson syndrome. The drug reaction. Certificate issuance. Day in and day out we issue certificates. Very peculiar problems. Diagnostic process. Pardon me for my saying, don't mistake me, we will edit it later. This is the most important revenue measure. Don't mistake me. Not everybody. You are different. That much I can tell you. But the rest of the world slightly problem is there. Administering injection resulting in gangrene. Arterial puncture and amputation, and intramuscular leading to paralysis. Okay. Let me take one by one. First thing, how competence is a matter of legal issue. How and under what circumstances it takes place. In fact, a particular case which raised lot of debate, that is with regard to failure of diagnosis. Does it constitute negligence? You fail to diagnose the problem, still I have the problem. I go to some other doctor, he diagnoses, he treats me, gets cured, I come and file a case against you. In the process I say you are incompetent because your other colleague has diagnosed, you have not diagnosed. This is one area which is a very, very significant legal issue, particularly for physicians. But when it comes to the patient, the issue is sometimes the possibility, the pain, suffering what the patient is undergoing is minimal in nature. Sometimes a loss of earning wages, or sometimes even it could result in death. These are the various related legal issues. For instance, if you just look into our radiologists, the problem is slowly escalating like anything. It's a real problem. The problem particularly for pregnant mothers, where you take a scan and you interpret a particular either stage or age or whatever, fetal, and some problem, etc., etc. The baby bonds with a particular problem. In one case, what you call twins, but she gave it in writing, one fetus, and she delivered twins. I mean, these are the various issues where the patient claims competence. No, you are not competent. Second important thing is patient referral. The peculiar problem we face patient referral with regard to the diagnostic process. For instance, a scan, whether the person is pregnant or not. Okay. Now, the issue is the person who undertakes the diagnostic process is different. The doctor who refers the patient is different. Okay. Now, the issue is who is under an obligation to communicate to the patient whether you are pregnant or not. The woman herself may not know that she is pregnant. Possible? Possible? Yes. There are several cases we have very much more. In such circumstances, what is the duty on the part of the doctor insofar as communicating that aspect to the woman? If so, what precaution is to be? If not, there is, I mean, there is no, if you think that there is no duty on the part of the, is it on the part of the diagnostic process? But if you look into the diagnostic process, the real life situation, you know what happens. The doctor who is expected to be with the patient along with the machine, he will not be with the machine. He is always in his chamber. A lab technician is with the person with the machine. Lab technician is like 10th class or PUC. He got some diploma, some kind of thing, and he has his own kind of things, etc., etc., in a sense. What do we do? She was pregnant and there was a problem and she was asked to abort. So many problems happened. She files a case. What is to be done? How do you decide? What is the yardstick you have? Where is it provided that the doctor who refers the patient must communicate with the patient? or is it the responsibility of the person who is expected to undertake diagnostic process? What is to be written? Patient referral. Normally, we write the name of the place where she has to go. Correct. Nobody can challenge me. If I am clear, that's it. If I am not clear, I don't speak. I have seen prescriptions where the patient name, age, and etc. That's all. The next thing in bold letters is the place where she has to go. But please remember, instruction must be not only verbal, it should be in writing. That's what National Commission has said. When you say that a particular diagnostic process has far-reaching implications on the quality of life or the born, newborn, etc., we are talking about a woman who is in the reproductive age group. Please remember. For example, a woman who is elderly, I don't think you have such kind of problem. There the problems are something else, some other category. Then comes the most significant one, Stevens-Johnson syndrome, whether a doctor is to be held liable. If so, on what basis? What kind of duty? What is the duty of communication on the part of the doctor? Is there no duty on the part of the patient to communicate with the doctor? Why you only talk about only duty on the part of doctor? For instance, I was taken to a particular some ear problem long back when I was 7 or 8 years old. The doctor gives, in those days the big thing they used to put steel one, I don't know what is the apparatus. I'm talking, some kind of thing he has done and absolutely fine. I came and they gave me food, I slept. Next day I came, my face has become like this. I thought, my parents also. Then King George Hospital, Visakhapatnam, one of the reputed hospitals, even today, I can tell you. Again taken, then doctor said nothing to worry. Now I realize some problem is there. But he did not blame my parents or something like that. Maybe first time you are coming to know this kind of thing. There is nothing to worry. There is a kind of antidote, this, that, etc. By evening, I became to my normal position, etc. and everything. Then he wrote it in the document. During his lifetime, Jogaro should not get sulfur. Therefore, I am saying there is a duty on the part of the patient as well. It is not merely doctor. Please remember, the doctor's duty corresponds with the duty on the part of the community. That is the reason why majority of the cases the courts have come to the conclusion, because the administered drug in the event of no warning from the patient, if the doctor administers, doctor cannot be subjected to liability. Now the point is, drug administering related consequence of a death is different from drug reaction and the person dying. Please remember. When we talk about drug reaction, some kind of possibly, I am not saying that in every case, extrinsic exterior reaction you can see sometimes. Sometimes it may lead to death. It could be the underlying reaction of the drug. Therefore, it is very difficult to say which one, etc. But what judges felt is a reasonable care if the doctor has taken, then there is nothing to be called negligence on the part of the. I am interested in giving this particular case. This is something, it's not from Bangalore, it is from Pune. Around 8:30 in the night, he was about to close the clinic door. Then one mother came with a baby. She said, baby is not moving, please just examine. He said, come. He examined. He said, I'm sorry, baby is dead. Then she cried and we didn't know what. Sir, you do one thing, give it in writing so that we will dispose of. He said, no problem. He gave a certificate and disposed of. After 4 days, inspector came. Police inspector. Are you a doctor? Yes. Where did you do your MBBS? He said, from Pune only. Since how long you are practicing? Did you give the certificate? Yes. Can you identify to whom you gave the certificate? Yes. Any other questions, doctor asked? No questions, only actions. You are under arrest. Arrested. Taken to the custody. What actually the inspector alleges is, this is a medico-legal case. The way you gave certificate, it is to fudge reality. That is, it is to wrap up the reality. What happened? They belong to lower middle class community, works in a factory. That day evening, he returned from factory in an inebriated condition. father. The child was crying, some problem, etc. Quite intolerant of the crying, he just did this and against the wall. Without any bleeding injury, the child died. Both wife and husband sat together. They said the best way to dispose of is to get a certificate and dispose of. That's how he has been taken to the doctor. Okay, that's fine. Intelligent parents, very rarely you will find. What doctor has done? The doctor has given a certificate. This is to certify, this is the thing, etc., etc. He wrote in Marathi. This is the thing, etc. The dead person, the body was this, that. What inspector says is, you know that the baby was brought dead, but you gave a certificate saying dead. There is a difference between a dead or a brought dead case. Yeah. A dead case is not a medico-legal. A brought dead case is a medico-legal. You have converted a medico-legal case into non-medico-legal case, for which you have charged 5,000 rupees. Therefore, you are arrested. I received a call. I went there. He was in the custody. First day he was not released. Second day, Chief Judicial Magistrate, arguments. By then, already media covered beautifully. Court packed hall. And I was asked to argue. That was my first year of practice. I was worried. See, I am worried what happens if it is okay, he will be released, other he will be. Then judge said, you are not from Pune, where are you from? I said, I am from Bangalore. This. Okay. Carry on. I said, I don't know Marathi, I can speak in English. He said, nothing. What is the problem in this case? I said, the problem is, in this case, the doctors are not trained in saying what is the content ought to be in a certificate, I said. Everybody laughed. A doctor who is MBBS, he doesn't know what is to be written in a certificate, and you are a lawyer from Bangalore telling us. What a beautiful lawyer you are. And this is the argument. What are you talking? I said, you may laugh at me, but that's a reality. He didn't understand, he didn't appreciate. Hey, what are it's a nonsense, he said. You don't know the way the doctors do. The way, left, right, center, they take money and give the certificates. And you are saying, I said, I can tell you about my client. I can't tell about Dr. X. I knew him. I can tell you with authority. Then he asked, what is your specialty? I said, this is my specialty, this is the thing, I was working here, just we gave. Then he understood, here is a person who is talking something sense because of his association. I said, you can talk to anybody, this is the thing. It is a case. See, merits of the case, whether he has done it or not, that we will see. We are talking bail, that's all. He is a native of Pune, he has his own establishment, he has his thing, etc. Don't go by what media projects. That's not reality. I can tell you very honestly. No, tell me how much he must have charged. Judge wants to know. Spice. Then I said, you will be surprised to know. Normally for a certificate he charges 30 to 35 rupees. Even that money he has not charged from this woman because she was in such a precarious condition. Released on bail. I am driving home the point, he is very lucky that he got the bail. I did not argue any law. What law? Nothing. But I mentioned to the people realistic thing. Is it not true? I am not saying that the present generation are informed. I think slowly with continuing medico-legal education, etc. But otherwise, how many of you, tell me in this hall, honest answers. How many of you know the difference between brought dead and dead?
We are certainly not trained to fill this.
Correct. To tell you very frankly, the certificate also, 1/8 sheet, where his name MBBS, general practitioner, is that some, no, I think family something is written, and this is handwritten, Marathi. I said, he doesn't know. Therefore, an innocent doctor must be protected. And now in his lifetime, he will not give you certificate. Lifetime, he will not. And he said, correct. And you will be surprised to know, the case, he got B report. That is, there is nothing against, and the doctor was acquitted, etc. But that's a nice feeling.
He did not say that the cause of the death. He said not to say that it's unnatural, natural.
Yeah.
He said he just wrote dead.
Correct.
You bring a dead body to a doctor, the doctor will say dead.
Yeah.
Did he write in that he died a natural death?
No. Please remember, insofar as medico-legal cases, your question is good. Insofar as medico-legal cases are concerned, please understand, it's a very complex area. Law only partly or partially deals with that, not completely. Therefore, we need to be a bit careful. The problem here is, suppose she is my neighbor. Something happens to my neighbor's house. Then I will kindly come and see and give a certificate so that we will dispose of it. She comes and gives a certificate. Is it not true? Many times it happens. How many people examine? Examination, what examination you are referring? Examination means only you have to do post-mortem. Then only you will come to know the cause. Here, examination means what a practitioner can, within his limits, can examine. That's it. That is the reason whenever you give a death certificate, you have to write, please remember, brought dead means brought dead fundamental, whereby you have an obligation on the part of the doctor to inform the police station of the concerned jurisdiction. If it is dead, you have to mention in the death certificate, it requires a further detailed examination, always, to ascertain the cause. You know, there is a difference between the cause of death and mode of death. I am not a doctor. Cause of death, mode of death. You may be able to ascertain mode of death, but underlying cause you may not be able to. Sometimes it may be, I am not saying, but there is nothing like white and black, that is what I am saying. That is the reason why judges are also say, I mean, if you think as a professional service provider, you are not confident, etc. It is better you ask them to go to the hospital, and accordingly the procedure is there. What is the procedure? They will admit the dead body, and they say post-mortem, etc. Then you cremate, there is no problem at all. Suppose a patient whom I was treating, okay, I know the underlying condition, the patient dies, there is no problem at all. I can give a certificate saying that because I was the treating physician, etc., etc., and could be the possible. Even then, you may not be knowing the cause of death. Is it not true? For example, cancer patient, or some other patient, or diabetic patient, or some other disease. Exact cause, I don't think anybody would know. But by probabilization, you may come to the reasonable cause. I think this kind of thing, you need to be a bit careful. Okay? Moving on to the next important thing, this arterial punctures, etc., I mentioned in my previous lectures also. One message I wanted to give is, when we talk about a physician, please remember, physician-led surgical practices are slowly disappearing. You agree or you don't agree? You don't now. See, previously you go to a clinic. Clinic means what? Only physician was there. Physician examines, etc., etc. Then he says, possibly this is the thing, etc. Then he instructs surgeon, this is what you have to do, etc., etc. Physician-led surgical intervention by the surgeon. But nowadays, that kind of specific roles and responsibilities we are not. Therefore, the competence on the part of physician is again and again challenged. And almost all certificate issuance, etc., or injection related, etc., they form the next part of the medical negligence normal cases.